from RTO Doctor, and I'm Raylene Bartlett. Today I'm going to talk to you about some unlawful directions and a distinct lack of government interest in relation to some issues that I've been seeing in the sector for the last few weeks that very few providers would be aware of, and should be of great concern to lots of people throughout the industry. I will give people a little bit of time just to join us because YouTube has decided to not play nicely with us again. So we're having to go live through Facebook, and then I will upload it to all the social media pages at a later time this evening, and also upload it to the YouTube channel. I will also be posting some notes that I have pre-prepared that I will be using to guide the video today. The reason being is that there is some really important information with legislative references that I'll be referring to, and there's also a lot of information, and I don't want to get distracted and sidetracked, as I often easily can be. So what I would like to do is try and stick as much as possible to my notes and make sure that everything that I had planned to cover can be covered, because I appreciate that my videos have been quite long and people just want to get to the nuts and bolts, and unfortunately sometimes I get distracted. So rather than take that chance, what I would like to do is just stick to those notes, and I will put them up in the comments section a little bit later for everybody, as well as some of the other documentation that I will be referring to. Now, I also just want to mention, if I'm talking a little bit funny today, it's because I had dental surgery last week and I had a tooth removed and my mouth is still a little bit funny. So if I sound a little bit funny, please just excuse me. But the overview of today's video, I would just like to discuss very briefly, so that way if you do have to go, or you don't think that you want to hang around for the full length of the video, at least you know what you'll be missing out on. So the overview of today's video, we're going to talk about three things in particular. The first being some potentially unlawful conduct by the regulator in the way that it performs its functions as the national vet regulator. We're going to look at section 157 of the NVR Act in particular, and use it against two clear directions that I personally have been given in the past few weeks by ASQA, and one of them is in relation to re-registration of RTOs, and the other one is in relation to the lodgement of a false statutory declaration. I just want to put it out there as the second point and be very, very clear and explicit about this, that each of these issues were provided to government ministers who are currently sitting in Parliament representing us as the Australian public taxpayers, and evidence was provided to support these things to those ministers, and no action has been taken. And it is for reasons like this that the Enough is Enough campaign exists. It is absolutely to bring transparency and accountability to the activities and practices and policies of the National Vet Regulator. And when the media and government ministers who are currently sitting members of Parliament refuse to pay any attention to the evidence that is so explicit in these breaches of the NVR Act and the regulator's functions, and they choose not to do anything with it, then there is a clear issue here that needs to be investigated. The other final issue that I want to briefly talk about today is in relation to CRICOS providers and an incorrect legislative interpretation by non-legally qualified auditors that is resulting in cancellation decisions and sanctions. A little bit more about that shortly, but it also has a direct impact in relation to section 157 of the Act and the functions of and performance requirements of the vet regulator. So I'm also going to put a link to the NVR Act in the comments of this video, but also what you will find in the notes of what I'm going to put up in the comments is the extract of section 157 of the NVR Act also, so that you can see for yourself exactly where I'm referring to and what I'm talking about. So in relation to the issue around re-registration, specifically we're looking at section 157, subsection 4, and what this is about is the regulator must apply the regulatory risk assessment framework in the performance of its functions. Now, obviously, if an RTO is applying for re-registration, then ASQA, as the National Vet Regulator, is required to perform its function as a regulator in making an assessment of that application and determining whether or not to re-register that client. So I'm just going to go on and read a little bit for you so that you get a real understanding of where I'm going with this, because it is quite tricky in some respects, but hopefully if you don't understand, you'll put some comments or questions and I'd be happy to respond to them. So what we're looking at is ASQA's regulatory risk framework, and I will put a copy of this on the video links as well in the comments, but basically it can be found on the ASQA website. I downloaded the current version today, 19th of November 2019 at 4:30 p.m. Western Standard Time, and it states that it is version 1 April 2016. It is the current version that is live on the ASQA website. In its regulatory risk framework, ASQA states that in relation to risk assessment relating to a provider and a case, the level of risk is determined based on the likelihood of measures of the provider's past performance and the provider's conduct in this case, as well as the impact on students, industry, and the sector more broadly. It's really important that we remember that this is the purpose of the regulatory risk framework. These likelihood measures can then be combined and applied to the matrix, and a level of regulatory response can be determined. ASQA then provides a diagram demonstrating the hierarchy of regulatory responses that it uses relative to the risk posed by an allegation or proven breach. Again, ASQA uses provider profile and conduct as a measure for determining its regulatory response. And it's been very vocal and transparent about that's how it's going to approach risk assessment in relation to any regulatory activity that it performs. It is clear in the meeting that I had with ASQA, I think it was 2 weeks ago now, that the regulatory response that will be provided has been preempted and predetermined and is not consistent with the regulatory risk framework that is live on the ASQA website today. The decision that was communicated to me was that any RTO who is seeking re-registration, if it has any non-compliance, no matter how minor, they will immediately be issued with a notice of intent to cancel. The reasoning behind this is I was explained that it is expected that an RTO is compliant with the standards for RTOs in the Vet Quality Framework at all times. That is a condition of registration. It is ASQA's expectation. So if it finds that there is any non-compliance, no matter how minor, the provider will always be issued with a notice of intent to cancel. That is the communication that was received by me from a senior ASQA person 2 weeks ago in a meeting. Now, as you can see, this is clearly the complete opposite to what is dictated in the regulatory risk framework. So what we have here is a preempted and predetermined policy decision that it doesn't matter how the regulatory risk framework is implemented, it might as well just be there as a mechanism that will never be implemented, because ASQA is never going to implement it anyway. They're going to do their own thing and implement this unofficial policy. So continuing on with the regulatory risk framework, in accordance with the framework, ASQA supposedly considers whether the most appropriate response is within its legislative authority and justified by sufficient evidence. It involves an escalated response where previous attempts to encourage compliance have been unsuccessful or where circumstances warrant. And it's consistent with precedents set by treatment of other providers in similar circumstances. Again, we can only ask the question for absolute transparency and accountability. How is it that ASQA's preempted and predetermined policy is consistent with its regulatory functions under Section 157(4) of the NVR Act? In the context of monitoring and review of a provider's risk profile, ASQA maintains that it manages provider risk by continuously reviewing provider performance through a centralised report. It also states that a provider profile is fluid in nature and does not translate into a single score or rating of any kind. The principles underlying ASQA's risk-based regulatory approach state that ASQA efficiently uses resources to effectively identify and target the most serious risks and patterns of systemic non-compliance while minimising costs on regulated entities. It seeks to minimise the regulatory burden for proven high-performing providers with a history of compliance, and applies procedural fairness in regulatory decisions and is transparent about frameworks that guide that regulation. I strongly believe that ASQA is not complying with these principles in the application of risk management and managing the risk that genuine providers create for the regulator. The regulatory risk framework refers to ASQA's requirement to apply a risk-based approach to regulation under the NVR Act. It also requires ASQA to implement proportionate risk-based regulation that minimises impact on the regulated body, including RTOs, consistent with the Commonwealth Regulator Performance Framework 2014 and in accordance with its requirements under the Public Governance, Performance and Accountability Act 2013. There is clear evidence here that ASQA does not meet these requirements. Despite being an independent statutory authority, ASQA is still bound by the Commonwealth's Regulator Performance Framework and the Public Governance, Performance and Accountability Act 2013. The elements of the Regulator Performance Framework include that regulators do not unnecessarily impede the efficient operation of regulated entities. Communication with regulated entities is clear, targeted, and effective. Actions taken by regulators are proportionate to the risk being managed, and regulators are open and transparent in their dealings with regulated entities. Key Performance Indicator 1 of the Regulator Performance Framework clearly states that enforcement activities only occur when there is a clear case for doing so. Page 19 refers to advice provided to regulated entities is consistent with communication policies. Yet, as we've clearly demonstrated earlier, there is no consistency between ASQA's official and unofficial communicated policies and its implementation of those policies. If you've got a policy in the risk regulatory framework that clearly states that your re-registration will be assessed based on the risk assessment framework, but ASQA have an unofficial, uncommunicated policy that it's going to implement that no matter how minor a non-compliance an RTO has when it's applying for re-registration, it will automatically be issued with a notice of intent to cancel. There is a clear inconsistency between their practice and their policy, something that it condemns RTOs around the country for every single day. Key Performance Indicator 3 of the Regulator Performance Framework clearly states that efficient regulation takes account of the regulated activity, the nature of the regulated cohort, including its compliance history, and penalties proportionate to both the seriousness of the breach and the risk being managed. One of the measures of good regulatory performance, according to the framework, is that regulators recognise the compliance record of regulated entities, something which, again, as has been demonstrated through this response and this video, ASQA indicated will not be considered. They have preempted and predetermined what the regulatory response will be before they've considered any kind of evidence that you may provide as a provider. In relation to the statutory declaration issue, apart from inconsistent information about what actually needs to be updated in ASQAnet for the purposes of notifying of a change of PEO or Principal Executive Officer for a CRICOS provider, I personally, on behalf of a client, have been instructed by 3 different people at ASQA that my client must perform an unlawful task to notify of this change of PEO on CRICOS. Again, not only has the unlawful nature of this demand been made explicit to the 3 ASQA staff involved in these demands, but evidence has also been provided to a sitting Minister of Parliament whose office agreed that it was an unlawful request and to send the evidence to them. Again, no action was taken by ASQA, the Minister, and the notification remains incomplete because to sign a false statutory declaration is an offence. Apart from committing an offence under the Statutory Declarations Act 1959, the client would also then be in breach of clauses 2.1 and 8.5 of the standards for RTOs 2015 and consequently the NVR Act in various places, including but not limited to, for example, Section 21, Section 22 and Section 111. This list doesn't even include any offences under the ESOS Act or any other legislation that might apply to making a false statutory declaration under the Statutory Declarations Act 1959. So what is it that makes this a false declaration? The template form that the incoming CEO of a currently registered CRICOS provider is required to sign. It will be uploaded in the comment section of the video with relevant highlights so everybody can see. It is clear as day. The incoming CEO is required to declare that they are applying for initial CRICOS registration, that they comply with the National Code 2007, which was repealed on 1st of January 2018, almost 2 years ago, and replaced by the National Code 2018, and that they were submitting a vast range of evidence that was not only not required for this purpose, but was completely irrelevant to the function of notifying of a change of PEO. How many CRICOS providers have completed this stat dec without taking any notice and therefore unconsciously made a false statutory declaration under the Statutory Declarations Act? The issue began on 8th of October 2019 as I tried to make the relevant application on ASQA.net on behalf of my client. Over a period of 2.5 weeks, several communications occurred with ASQA over the issue. A 4th ASQA senior manager was advised of this issue via a formal letter from the client's lawyer on the 6th of November 2019. On the 7th of November 2019, that senior manager advised that they had sought advice on the matter from the relevant business area within ASQA. I am advised that an ASQA representative will be in touch with your client as soon as possible with the correct form to be completed offline and subsequently uploaded. As at today's date, 19th of November 2009, 11:30 a.m. Western Standard Time, the correct form has still not been provided and it's still not been uploaded into ASQA.net. So if you are an incoming CEO of a CRICOS provider and you're being asked to complete this incoming CEO notification stat dec, I strongly urge you to seek legal advice because you may actually still be committing an offence under the Statutory Declarations Act 1959, and ASQA and current sitting ministers are well aware of the issue and have done nothing in response to our concerns and the evidence provided. In relation to the CRICOS issue, we have concerns with Section 157(1)(j) and Section 157(q)(2) and (r) of the NVR Act, and it is in relation to advice that has been provided in an audit report detailing non-compliance with the NVR and ESOS Acts in relation to providing refunds for student default where there is a visa refusal. This issue has never been required legislatively to be performed in the manner demanded by the auditor. The issue has never been issued as required by the department or PRISMS. The PRISMS website includes no evidence of this requirement in the news section, nor has it ever that we've been able to identify. The PRISMS Administrator Guide provides no reference to this requirement. The PRISMS training makes no reference to this issue. The recent webinar provided by PRISMS on changes also makes no reference to this requirement. CRICOS providers have, generally speaking, never been alerted to this issue unless it has come up at an audit. So what is the issue? ASQA auditors are now issuing sanction notices and intention to sanction notices for allegedly not meeting their ESOS reporting obligations for a refund in the case of a visa refusal if they do not click on a specific button on PRISMS and report it in that manner. Never mind that notification can be reported legally and meeting the client's legislative obligations in a different manner. Firstly, from an operational and student journey perspective, just because a student's visa has been refused does not necessarily equate to them requiring a refund immediately. The reasons for this are various and include, but are not limited to, for example, the student is appealing the decision to refuse their visa and wishes to retain their proposed enrolment. However, they may wish to vary their commencement date. They remain on shore and they're studying on a different visa or even the same visa, and their student visa remains valid. The student has not yet decided that they no longer wish to pursue enrolment. The student must apply for a refund before one can be processed. While it is true that PRISMs now advises providers when a visa has been refused, this does not automatically equate to a situation where a refund should be or can be immediately generated. The default day under the ESOS Act is not determined by the date that the visa is refused. It is determined by very specific actions provided for in Section 47A of the ESOS Act. Importantly, any refund must be consistent with the legislative requirements and the provider's refund policy and procedure, and provide all relevant evidence and details for the provision of such a refund. In accordance with Section 157 of the NVR Act, ASQA has a responsibility to provide education and information in relation to assisting providers to maintain compliance with their registration obligations. This is a clear failure of that obligation. Not only is it a clear failure of that obligation, but in addition to the full cost recovery issue that is currently out for public consultation, where ASQA are saying that they have a budgetary mandate to go into full cost recovery from the 1st of July next year, they've also just been given by Michaelia Cash's government an extra $18.1 million for the purpose of educating and informing the sector more broadly about its regulatory intentions and requirements. Secondly, this is not the first time that I have had a non-legally trained auditor, just to repeat that because it came out a bit funny, a non-legally trained auditor dispute the legality of a legislative requirement with a practicing lawyer. It is unfortunate that this is the case because sadly, the auditors responsible for making these decisions that lead to cancellation following ASQA's internal tick-the-box forms are legally flawed, and very few providers have the capacity to take matters such as these to the federal court where such unlawful interpretations can be challenged. This is an issue that I have addressed quite widely in this book, and it is also supported by relevant case law, also addressed in the book. So if you still haven't signed the petition, I hope that today's video and videos over the past few weeks have demonstrated why an independent review of ASQA is urgently needed. If you haven't signed, stop the rot, enough is enough, and sign the petition. We will be adding a link to the petition so that people can jump on board and sign it. It does close tomorrow, so it's critical that you make sure that your signature is counted in the next 24 hours. We will still be providing further videos in relation to enough is enough and more client testimonials. We have a number of people who have come forward and made it very clear that they wish to disclose their stories publicly because they feel that ASQA are unaccountable and not being transparent, and the Australian public deserve to know what's really going on because government and media are clearly not interested in the truth. I also just wanted to say that I have given the government one further opportunity on Friday afternoon where I will present all of this evidence again in the hope that they do finally listen. This person does have a lot more clout, I believe, than the previous ministers that I've been speaking to, but even the Shadow Minister for Education and Training has been reluctant to provide resources to speak with me. Something that I actually questioned last week was how much resource does it take to make a phone call? I still don't understand why they didn't have sufficient resources to do that, given the damning evidence and information that I've got that would surely strengthen her portfolio. I have previously spoken to and been interviewed by Paul Farrell at the ABC, as you know, who chose to do a completely different story. He could have chosen to represent those providers and those stories that we're trying to bring to the surface, and he chose instead to bring up a 4-year-old vet fee help scandal story just prior to the consultation document from ASQA on its full cost recovery fees and charges being released. I strongly urge you to take a look at the full cost recovery consultation paper and the associated CRIS document, the Commonwealth Risk Assessment Statement. I hope to be providing a further video in relation to that proposal in the coming days, if not over the weekend, once I've had an opportunity to go through it in more detail. But for me, there appear to be some very significant inconsistencies in that proposal, including the fact that the financial data that they're relying upon is not consistent with the same expectation that they have of the very providers that they are required to regulate. For example, if a provider provided a financial viability risk assessment tool and it was for years that were different to the financial reports that had been provided, it would be sent back and the application would be rejected. But that is not what we've got in the case of the consultation document and the CRIS. What we have in relation to that document is a proposal that is based on a Commonwealth risk impact statement dated from last year. And the financials obviously are not consistent with the proposed document. So that is something else that I will be talking about in the next few days once I've had an opportunity to go through it in more depth. I would like to thank you for joining us today. I will also put those links and documents in the comments. If you have any questions in relation to today's video, please don't hesitate to contact me offline. And please make sure that your signature is counted in the petition. We are hoping that all of the signatures will lead to the Australian National Audit Office conducting an independent review of ASQA's regulatory policies, practices, activities, and that it will lead to a much fairer vet sector where the regulator can no longer be accused of being rogue, corrupt, and full of conflicts of interest. Thank you very much for your time, and thank you for listening, and I look forward to everyone's signatures being on that petition. Bye for now.